This is part 17 of my journey through the Connecticut court system over the last 10 years. At the end of part 16, I was talking about the November 5th, 2019 hearing, which was the first time that Matt and I ever went to court together for Angelina. And I was going through all of the perjury and lies that he did on the record and was last discussing his criminal intent and willful deception. So as I was saying at the end, the systematic nature of Lodice's false testimony establishes criminal intent rather than inadvertent error, satisfying the willfulness requirement for perjury charges under Connecticut law. His calculated responses to questions about business expenses, employment status, and income demonstrate conscious deception designed to minimize child support obligations. The fact that he maintained this deception, even when confronted with contradictory documentary evidence, shows specific intent to defraud the court and evade his legal obligations to his daughter. Lodice's attempted manipulation of legitimate 1099 contractor status to hide income represents a sophisticated fraud scheme that extends beyond family court into potential tax fraud territory. By claiming business deductions for expenses paid by his employer while simultaneously underreporting income, Lodice violated both family court disclosure requirements and federal tax laws. This pattern of systematic deception across multiple legal forums demonstrates consciousness of wrongdoing and criminal intent that warrants prosecution under both Connecticut perjury statutes and federal tax fraud laws. The materiality of Lodice's perjury becomes clear when considering its direct impact on child support calculations. Connecticut uses an income shares model where child support is calculated based on both parents' combined net income. By falsely testifying that his annual income was $13,000 instead of the actual $71,753.25, Lodice attempted to reduce his child support obligation by approximately 82%, representing fraud that would have directly harmed his daughter's financial support. Under Connecticut child support guidelines, this income differential would have resulted in dramatically different support calculations, potentially reducing Lodice's monthly obligation by hundreds of dollars. The systematic nature of this deception, combined with his use of fabricated business expenses to further reduce his apparent income, demonstrates a calculated scheme to defraud both the court and his child of legally mandated financial support. This type of financial fraud in family court proceedings undermines the entire child support enforcement system and constitutes a serious felony offense warranting both criminal prosecution and civil contempt proceedings. The November 5th, 2019 hearing transcript provides overwhelming evidence of systematic perjury and financial fraud committed by Matthew Lodice through false testimony about his income, employment status, business expenses, and financial capacity. This pattern of deception represents not only multiple felony perjury violations under Connecticut General Statutes Section 53A-156, but also potential federal tax fraud and child support evasion that demands immediate criminal investigation and prosecution. After all of that, which was the November 5th, 2019 hearing, which is posted on Pro Legal Solutions on my YouTube channel, Pro Legal Solutions on YouTube. That is a real good example of him lying under oath, committing fraud, committing tax fraud, tax evasion, perjury, and repeatedly lying under oath. And so November 7th, 2019, 2 days later, we were scheduled to come back to court for a hearing for custody visitation in the family court. I showed the transcript last time and I hadn't had the audio, and now I do. So this is actually the audio of the November 7th, 2019 hearing. So you can actually see exactly what happened. This was the day that I was granted primary residency of Angelina, and it ended with us having joint legal custody and me having primary residency, and he would have to see her based on his schedule. And I was able to get her a passport and have a couple other things where it was giving us a schedule to get us through the holidays. But basically it said after January of 2020, it would revert to based on dad's schedule. So this is the November 7th, 2019 hearing that I hadn't had played before.
Antar versus Lodis? Lodis. Good afternoon to both.
Good afternoon.
Madam Clerk, would you please swear the parties?
Yes.
Okay, good afternoon, folks. Have a seat. Did we give Mr. Lodis appearance form, or do I have it? Give me just a moment to look over the file, and then I'll just address the referral. All right. Thank you for your patience. Before I address the recommendation that I refer this matter to what we call our early intervention program, let me just make sure that I understand the background of the case. So we have what I'm sure is a beautiful young daughter who was born in May?
Yes.
Okay. Who is she presently living with?
She lives with me.
And you filed originally a custody application.
Yes, custody and as well as child support.
Right.
Yes.
Originally, I'm not sure why it was coded this way. The very first document you filed in September was described as a visitation application. But then you filed a custody application. But you're right. It says you're seeking, the request is sole legal custody, parenting plan, primary residence with you, and then a visitation schedule and child support, right?
Yes. I mean, we decided we want to do joint custody, but
okay.
Yes, everything else correct.
All right. So what are the issues that are in dispute? Let me break it down. So you're telling me the parties agree, at least at this point, to share joint legal custody.
We actually agree with everything. We came up with a full agreement as far as custody, visitation, and child support. We have it all written out, and we're ready to put that on record.
Yeah, so we're asking if you, because
Was this something that happened after you met with Family Relations?
Yeah, she was like really rushing us, and we didn't have time to go over everything.
Oh,
so
okay.
we kind of like, we met out after and then talked it, worked it all out ourselves, and then came back.
A rare occurrence, but I am very happy to hear that. So, ma'am, you have in front of you, is that the agreement?
It's handwritten, but I'm
That's
wondering
fine.
if it's okay if I read it and then they can type it as I'm...
Well, it doesn't quite work that way.
Okay.
What I'm going to do is have you give it to the marshal.
Okay, it's a little bit kind of messy, but for the most part, if you want, we can read it to clarify.
Let me just take a look at it first.
Okay.
Okay, thank you, Marshal.
Yep.
And the fact that I'm raising my glasses has nothing to do with the legibility. I'm just getting old, so... So let me see if I've got the gist of this. You have a fairly detailed parenting schedule through January,
Right.
correct? And then it provides that after that, basically you will, by mutual agreement, work out visitation on a week-by-week basis.
Yeah, we work
Yes.
for the same company, so we kind of
Okay.
understand our schedules.
All right. Where, and the child support number that's in here,
Yes.
how did you both arrive at that number? Did you use the child support guidelines?
The child support guidelines, I'm a private contractor, we're both private contractors.
Mm-hmm.
My write-offs are large, so it's a lot lower than it can be, than I could afford. So we came up with an agreement that's higher than what the guidelines would be.
So that's really my question. This is an upward deviation. So if you took your gross income based on your recent pay stubs, tax returns, whatever, and
Yeah.
yours, did you put that into the child support guidelines?
Yes,
And you came up with a number that was lower than 120?
yes,
So you're paying her more than you would under the guidelines?
yes.
And I don't see anything in this agreement, maybe I'm missing it, that says anything about legal custody.
We would like shared
You
custody.
want shared legal
Yes.
custody? All right.
And I also did put in there about unreimbursed childcare and unreimbursed medical.
Did not put in here.
I did put it in there. I'm not sure if you saw it. Just 50% of the unreimbursed medical and 50% of the unreimbursed childcare.
Oh, there it is.
Yeah, I wrote
Yep, I
that.
see it, sorry. Of all daycare and medical.
Yes.
Right. Did you fill out financial affidavits at any point today?
Not today, we did, we were actually here on Tuesday. We had a court appearance Tuesday for child support. And we were just at a very big disagreement with that because, like I said, my income was coming up as below minimum.
Yeah.
And they wanted to give her a low amount, and we kind of bumped heads with that. So then we came up to our own agreement that was better than that.
Yeah, so that on Tuesday was in front of the magistrate, and they told us today in family relations that we could do both child support as well as the visitation in this court.
So is there a docket pending, a matter pending in magistrate court?
Yes, but we plan on withdrawing that if we can settle everything today. So we wanted to just, get it ordered today and then not have to come back.
All right, and who filed the action in probate court? Excuse me, probate court. In the magistrate court, you did?
I did.
What was the reason for filing it in magistrate court as opposed to here? That's really all.
So basically, I did it. I did through the Department of Social Services,
Right.
and I did that months ago. And it took them a long time to get me a court date. So in the meantime, while it was taking so long, I filed through the regular court for
Are you
both.
receiving what they call 4D services?
Yes, Husky insurance. So
Just the Husky
and food stamps.
and food stamp, okay.
Yes.
I'm not sure, I'm embarrassed to admit this, I'm not sure that this court as opposed to the magistrate court, since you're receiving 4D services.
We were told
We did
as long as
ask.
she's not receiving food cash.
As long as we're not
Is that what
receiving
they said?
cash
That's what they told
assistance,
us.
they said we would be able to hear it in this court. So they said it doesn't make a difference. It's our
Because otherwise I
preference.
have to pay back the cash if she receives cash.
Understood. So, is it your intention that this agreement that you've negotiated would be a final agreement that resolves the custody application, everything that's under the docket number in this case?
Yes.
Yes.
All right. Here's what I can do today, here's what I can't do today. What I can do today, and I'm happy to do today, is enter this agreement as a temporary agreement. The reason I call it temporary, I can't enter a final agreement without financial affidavits and child support guideline worksheets. I just can't do that. Now, if you'd like, you can step outside the courtroom, go down to room 119, which is the court support, court service center, and you can fill out financial affidavits down there and the child support guideline worksheet, and then you can come back up here, and then I'll have those documents, and I'd be prepared to make this a final agreement, and you wouldn't have to come back. But until and unless I have those documents, I can't enter this as a final judgment. So how would you like to proceed?
So if we just go downstairs, get a financial affidavit, fill it out, and come back?
Yeah,
You can
come right
order
back
this
here.
right now?
Yeah, it's only 3. I'm here till 5.
Okay, yeah, we can do that.
I'm sure you can do it within an hour. So what you need to do is fill out the financial affidavits, and somebody will help you with the child support guideline worksheets. Just come back up with those, and then I'll enter final orders on this.
Sounds good.
Okay.
Thank you.
Thank you.
Good afternoon, folks. All right, the court will continue the matter of Antar versus Lotus. Thank you, folks, for filling out the financial affidavits and the child support guidelines. Do you have the... oh, here it is. All right. So, based on the financial affidavits that you provided, the presumptive amount of child support that hold on. The dad would pay mom is $55 a week.
Yes, Your Honor.
But is it still the case that the parties have agreed that you'll pay $120 a week?
Yes, Your Honor.
Okay. And that, you believe, is in the best interests of the child?
Definitely.
I say that word because that's, what we're doing here is deviating from the child support guidelines. Now, this is an upward deviation, which I'm happy to do, but I just need to specify the specific reason for the deviation. Best interest is one of the matters.
Okay.
Okay. So,
Excuse me. Thank you.
what I'm going to do, I think that the written agreement that you've done is perfectly legible, all right? What I'm going to do is simply hand it back down to you and have both of you sign and date it just on the back,
Okay.
okay? And then, actually, wait, before I do that, let me add to it. I'm going to write on the back, parties agree to share joint legal custody, right? And primary residence is with mom, correct?
Yes, Your Honor.
Very good. Marshall? So just sign and date underneath, and then we'll give it to Ms. Antar.
7, right?
Yep. Thank you, Marshall. All right, the next, what I'm going to do is going to be slightly repetitive, but I'm just doing it so that we now have a clear record. And what I'm going to do is ask you standard questions that I ask in any custody case. There's nothing unusual about these questions. They're just to establish jurisdiction, date of birth, that kind of thing. All right, Ms. Antar, you are the applicant in this matter, correct?
Yes.
you are the mother of Angelina Maria Lotus, born May 21st, 2019, is that correct?
Yes.
Has Angelina resided continuously in the state of Connecticut since her birth?
Yes.
At the moment, are you receiving any financial support from the state of Connecticut, or is Angelina receiving any support other than Husky Insurance?
No.
Okay. And you and Mr. Lotus have reached an agreement regarding legal custody, physical custody, and a parenting plan and child support. Is that correct?
Yes.
Yes.
And just in general terms, this is a handwritten agreement which will be made part of the court record. Both of you have signed it in the presence of the court, correct?
Yes.
Did anybody force either of you to threaten to sign this document?
No, Your Honor.
Generally speaking, the agreement is as follows. Parties will share joint legal custody of Angelina, correct?
Yes.
Primary residence, physical residence will be with you, correct, Ms. Antar?
Correct.
In terms of a parenting schedule, the agreement sets forth a fairly specific schedule that governs parenting time between today and roughly the end of January 2020, correct?
Correct.
And then the agreement provides that thereafter the parties will work out visitation by mutual agreement on a week-by-week basis, correct?
Yes.
Yes.
The agreement also provides that you will have the authority to get a passport for the child.
Yes.
Is anybody planning travels?
Not yet, but
not
I
yet, no.
just in case.
In terms of child support, the agreement provides that Dad will pay you $120 a week in child support, correct?
Yes.
Yes.
Now, you understand that based on your respective incomes, which were then put into the child support guideline worksheet, the presumptive amount of child support that Mr. Lotus would have to pay is $55 a week. Is that correct, sir?
Yes, Your Honor.
So the agreement provides for what we would call an upward deviation from the presumptive amount to the agreed upon amount, correct?
Yes.
And do you both agree that that's in the best interest of Angelina?
Yes.
In addition, the child support guidelines specify presumptive percentages that each of you would pay for unreimbursed medical expenses and work-related daycare. You understand that?
Yes.
The presumptive amount is that Mrs. Antar would pay 70% of expenses and Mr. Lotus would pay 30%, correct?
Yes.
With respect to child care, Mr. Lotus would pay 20%, right?
Yes.
Under the
That's
presumptive
what
amount.
Yeah, okay. Yes.
But the agreement is for the parties to split 50-50 all unreimbursed medical expenses and work-related daycare expenses,
Yes.
correct?
Yes.
Let me ask you a question. Might not have come up. Have you discussed with each other how taxes will be filed or who will claim Angelina?
We haven't discussed it, but if she's living with me, my accountant has always said that whoever the child lives with is the one who claims the child.
Fine. And you agree with that, sir?
That's fine, yeah.
Okay. All right. Now, both of you are representing yourself. I'll ask you these questions, and then I'll follow. So, ma'am, you're representing yourself today, which is your right. But do you understand that if you wanted to, you could have retained an attorney to represent you in this matter?
Yes.
Did anybody attempt to prevent you or discourage you from hiring counsel?
No.
You also understand that instead of entering into an agreement today, you could have had a hearing, a trial, if you will, before a judge, whether it was myself or one of my colleagues. And the judge would have heard evidence, testimony from you and from the father, and that the court could have resolved the issues of custody, parenting time, child support. Do you understand that?
Yes.
And do you believe that do you understand that by entering into the agreement today, you're waiving your right to have a trial and the judge decide these issues?
Yes.
And you're doing so voluntarily and of your own free will?
Yes.
Do you have any questions about the agreement?
No.
And Mr. Lotus, those last few questions that I asked Ms. Antar, did you hear those questions?
I did.
And did you hear her answers?
Yes.
Do you agree with her answers?
Yes.
If I asked you the same questions, would you have answered the same way?
Yes, agreement with all of them.
And I asked both of you this before, let me do it again. Ma'am, do you want the court to accept this agreement and make it a final court order?
Yes.
And by final, what I mean is it will resolve the custody application. There won't be any further court dates with respect to the pleadings that you file. It doesn't mean, however, that people can't come back to court to modify any aspect of this agreement by filing a motion to modify. You understand that?
Yes.
But if you wanted to do that, somebody would have to file a motion. Understood?
Yes.
Yes.
Okay. Very good. The court will make the following findings. The court finds that it has jurisdiction over this custody matter. The court finds that the parties have one minor child, Angelina Maria Lotus, born May 21st, 2019. She has resided continuously in the state of Connecticut since birth. Other than Husky Insurance, the parties, nor the child have received any financial assistance from the state of Connecticut. The court has reviewed the parties' financial affidavits, the child support guideline worksheet, and the parties' written agreement. Upon thorough consideration, the court finds that the parties' agreement is fair, just, and equitable, and in the best interests of their minor child. The court approves their agreement. It is now an order of the court, and it will be incorporated into the final custody judgment. So this is a final order. Have either of you signed up for the parenting education program?
No, but we are doing co-parenting counseling.
We actually do our own co-parenting counseling outside of the court ourselves, just to help us work with each other. It's been very helpful.
Excellent. Hold on 1 second. So the co-parenting counseling you're doing is something that you've arranged on your own?
Yes.
Yes.
In light of the parties' representation that they are both currently engaged in parenting education program, the court will waive the requirement that they're engaged in co-parenting counseling. The court will waive the requirement that they participate in the parenting education program. Okay, you are all set. I'm glad that you were able to work this out over the course of the day. I know it's been a long day and it got off to a rough start, but I'm very pleased that you were able to work this out.
Thank
and
you.
I wish you both the best of luck, okay?
Thank you so much.
All right.